multiple hearings this morning, so we're going to get moving here and give them a chance to come and ask questions as well. I want to start by talking about, why we're here and how this all started, at least for me. In 2015, I learned the story of 8 unaccompanied minors from Guatemala who crossed our southern border. A ring of human traffickers had lured them to the United States. They'd actually gone to Guatemala and told their parents that they would provide them education in America. And to pay for the children's smuggling debt, the parents actually gave the traffickers the deeds to their homes. And the traffickers retained those until the children could work off that debt, because they weren't interested in giving them an education, it turned out. They were interested in trafficking them. When the children crossed our border, their status, as defined by federal immigration law, was that of an unaccompanied alien child, or UAC. So you hear the term UAC used today. The Department of Homeland Security picked them up and, following protocol, transferred them to the Department of Health and Human Services. HHS was then supposed to place these children with sponsors who would keep them safe until they could go through the appropriate immigration legal proceedings. That's practice. That didn't happen. What did happen is that HHS released these children back into the custody of those human traffickers without vetting them. Let me repeat, HHS actually placed these children back in the hands of the traffickers. The traffickers then took them to an egg farm in Marion, Ohio, where these children lived in squalid conditions and were forced to work 12 hours a day, 6-7 days a week, for more than a year. The traffickers threatened the children and their families with physical harm and even death if the children didn't perform these long hours. This subcommittee investigated. We found HHS didn't do background checks on the sponsors. HHS didn't respond to red flags that should have alerted them to problems with the sponsors. For example, HHS missed that a group of sponsors were collecting multiple UACs, not just one child, but multiple children. HHS didn't do anything when a social worker provided help to one of those children, or tried to at least, and the sponsor turned the social worker away. During the investigation, we held a hearing in January 2016. So this goes back a couple years, where HHS committed to do better, understanding that this was a major problem. 2016, of course, that was during the Obama administration, so this has gone on through 2 administrations now. HHS committed to clarifying the Department of Homeland Security and HHS responsibilities for protecting these children. HHS and DHS entered into a 3-page memorandum of agreement, which said that the agencies recognized they should ensure that these unaccompanied alien children weren't abused or trafficked. The agreement said the agencies would enter into a detailed joint concept of operations, so an agreement would actually lay out the responsibilities that would spell out what the agencies would do to fix the problems. HHS and DHS gave themselves a deadline of February 2017 to have this joint concept of operations pulled together. That seemed like plenty of time to do it, but it wasn't done, and that was over a year ago, February 2017. It's now April 2018. We don't have that joint concept of operations, so-called JCO, and despite repeated questions from Senator Carper and from me, as well as our staffs over the past year, we don't have any answers about why we don't have the joint concept of operations. In fact, at a recent meeting, a DHS official asked our investigators why we even cared about a JCO. Why? And let me be clear, we care about the JCO because we care that we have a plan in place to protect these kids when they're in government custody. We care because the Government Accountability Office has said that DHS has sent children to the wrong facility because of miscommunications with HHS and because of other concerns. We care because the agencies themselves thought it was important enough to set a deadline for the JCO, but then blew past that date. We care because these kids, regardless of their immigration status, deserve to be properly treated, not abused or trafficked. We learned at 4 p.m. yesterday that 13 days ago there was an additional memorandum of agreement reached between the 2 agencies. We requested and finally received a copy of that new agreement at midnight last night. It's not the JCO that we've been waiting for, but it is a more general statement of how information will be shared between the 2 agencies. Frankly, we had assumed this information was already being shared, and maybe it was. And it's positive that we have this additional memorandum. That's great. It's nice that this hearing motivated that to happen, but it's not the JCO we've all been waiting for. So we called this hearing today for DHS and HHS to give us some answers about the JCO. Once DHS hands unaccompanied minors off to HHS, the law provides that, quote, "The care and custody of all unaccompanied alien children shall be the responsibility of the Secretary of Health and Human Services," end quote. But HHS has told this subcommittee once it places children with sponsors, even sponsors who are not related to the children, it no longer has legal responsibility for them. Not if they're abused, not if they miss their court hearings, no responsibility. That's, of course, not acceptable and not workable. HHS, by the way, inherited responsibilities relating to these children when Congress dissolved the Immigration and Naturalization Service, INS. We continue to believe HHS has the authority and responsibility to care and keep track of these children. Since our 2016 hearing, we've also heard about other problems. We've heard that sponsors frequently fail to ensure these children show up at their immigration court proceedings. That undermines our rule of law and an effective immigration system. And in almost all of those cases, the judge enters an in absentia removal order. That means that even if the children are eligible for immigration relief, like asylum status, they don't get it and are ordered removed. That's bad for the children, too. We also learned that HHS does not track these children once HHS releases them to the sponsors, nor does HHS notify state or local governments when it places those children with sponsors in those communities. HHS says they do plan to start notifying local law enforcement when it releases a relatively small number of high-risk children. That's good, but it hasn't done so because it can't figure out who to tell. That seems like a pretty straightforward step. We should be able to at least figure that out here today. Since 2016, HHS has called sponsors and children 30 days after placement with sponsors to check on the children. That's a good step in my view. But in his testimony, Mr. Wagner says that between October and December last year, ORR tried to reach 7,635 of these children. Of those, he says, quote, ORR was unable to determine with certainty the whereabouts of 1,475 UAC. In other words, that's almost 1,500 kids missing in just a 3-month period. We'd like to know how HHS plans to keep track of these children. We've also heard about problems at the 3 secure facilities HHS uses to house UACs who are at higher risk, those accused of crimes who might do harm to themselves or present a flight risk. The head of the Yolo County, California facility says HHS does not give them enough money for the number of children they house, which means they can't hire enough staff to take care of the children safely. We've got a witness from the facility in Shenandoah Valley who's going to talk later today, who will tell us why their facility simply isn't equipped to handle some of the children that the HHS Office of Refugee Resettlement places there, and what can be done about that. And again, this is not an issue that just came up in this administration. This dates back to the Obama administration, now into the new Trump administration. And the topic of unaccompanied alien children obviously continues to be a hot-button issue generally. But today we want to focus on 2 key issues related to them. First, just human decency. Once these unaccompanied kids are in the United States, we have a duty to ensure they're not trafficked and not abused. Second, the rule of law. Our immigration system is clearly broken, and one problem is that half of these kids are not showing up at their court proceedings. That's not good for the kids or for our system. We need to do better. I look forward to hearing from witnesses today how we can make that happen, and again, I appreciate my colleagues being here. We'll go through the testimony quickly, and then I'll withhold my questions until you all have had a chance to ask yours. With that, I'd like to ask our ranking member, Senator Carper, for his